Across America, many communities are in what scholars call legal deserts, areas with few, if any, available attorneys to meet the legal needs of local citizens. Rural towns and poor urban neighborhoods often lack affordable access to lawyers, leaving residents without practical guidance in solving their legal problems. This shortage not only frustrates individuals seeking justice, but also undermines confidence in the justice system itself. It widens the gap between those who can afford representation and those who cannot. To help bridge this gap, a few states, for example, Utah, Alaska, and now Oregon, are experimenting with using non-attorney legal advocates. These are trained professionals, often known as community justice workers, who work under the guidance of a practicing attorney. Others, in Arizona, for example, are often called certified community legal advocates. They can work untethered from a practicing lawyer. These non-attorney advocates can assist people in certain specific legal areas, including family law, landlord-tenant disputes, employment issues, government benefits, domestic violence, or debt collection. These advocates work within the limitations prohibiting non-lawyers from offering what is defined as legal advice, a boundary carefully guarded by the laws governing the unauthorized practice of law. This prohibition is also codified in NACM's Model Code of Conduct for Court Professionals. Canon 1.7 states, a court professional is responsive to inquiries regarding standard court procedures, but does not give legal advice unless required as part of one's official position. While these restrictions safeguard the public from unqualified guidance, they also constrain non-lawyers from fully helping individuals through complex legal processes. These restrictions raise difficult questions about the balance between consumer protection and access to justice. I'm Pete Kiefer, and welcome to A Question of Ethics, a conversation on courts and ethics. In this episode, we're talking about communities that are legal deserts, where residents lack access to affordable legal help. Some states are experimenting with non-attorney legal advocates to bridge this gap. Is this a model for the future? Here to discuss these issues are Maggie Hum, Executive Director of the Alaska Legal Services Corporation in Anchorage; Sarah Carver, Co-Director of the Alaska Legal Services Corporation's Community Justice Workers Resource Center; Credell Webb, Diversity, Equity, and Inclusion Officer for the First Judicial District Court in Philadelphia, Pennsylvania; and Liz Rambo, Trial Court Administrator for the Lane County Circuit Court in Eugene, Oregon. Thank you all for joining today's Question of Ethics conversation. The concept of legal deserts is gaining attention. Residents in these areas struggle to obtain meaningful legal guidance. But the crisis over the lack of legal assistance isn't limited to rural areas. Low-income residents in urban areas also have trouble obtaining help. How serious is this, and is it a growing problem? Maggie Hum?
So Alaska Legal Services is the statewide civil legal aid provider where we provide free civil legal aid to folks that are low income. And I can say that, yes, here in Alaska, the problem of legal deserts, it is certainly not a new one, and it is a growing problem. And I can tell you a little bit about how it looks in Alaska. So most of our state is off the road system, meaning that you must travel by plane to get there from an urban hub. And once you're in a rural hub, the many small villages that can be accessed are accessed by, weather permitting, small planes, boats, or even snow machines. Communities are often lacking in basic infrastructure. Approximately 75% of our communities have no law enforcement presence. And the nearest courthouse may be hundreds of miles away, again, if you're able to get there by plane, weather permitting. There is an absence of attorneys in these rural communities. If there are attorneys present in some of the rural hubs, they're likely to work for a government entity like the DA's office or for a corporation. ALSC and our organization, and perhaps one or two others, lawyers in the community might be the only private lawyers who are available in a rural hub. And in most very rural regions, there are just simply no lawyers at all. So if you add to that fact that the data shows that Alaskans experience 2.1 civil legal issues per person every 18 months, That amounts to millions of civil legal issues every year. And there's only 1.13 attorneys available for every 10,000 Alaskans. So we turn away about every one person for every one that we help. And of course, attorneys are very unaffordable for the folks that are coming to us. Private attorneys are very unaffordable. And with so much funding uncertainty these days, our turnaway rates are growing. I would say the lack of access to help is not necessarily a rural issue. It's in urban areas, it's not so much a legal desert though, more it's sort of an access to justice desert, right? There are courthouses, there is law enforcement, there are lawyers, but legal assistance is simply unaffordable and out of reach for most people.
Liz Rambo?
Wow, Maggie's experiences are so incredible. And my perspective is quite different as a trial court administrator, but I have to completely agree that this is a very serious problem and a growing problem. Oregon is similar to Alaska, but smaller in that we have very large regions that are sparsely populated and that are rural and where legal service access is extremely, extremely low. Some of you may have seen the recent study by Iowa State University finding counties in the West and Southwest with really critical legal desert issues emerging, which was a really fascinating study. So I actually have some personal experience with this issue in that I needed to get legal assistance in Northern California. California goes underneath Oregon like this, boop, like that. And there's a place in California on the far east side, right next to Nevada and south of Oregon, that's nowhere. There's nothing there except desert and salt lakes and nothing, and people, and a few hundred people that live there. My mother-in-law lives there. We needed to get some estate help. And the only place to get estate help was an hour away over a 6,000-foot mountain pass in the next town over, where there lived one attorney who did everything. He had to know criminal defense. He had to know probate, small claims, everything. And just getting his attention to help us with this small estate was really incredible lift for him. It was remarkable to me because I live in Western Oregon and the scope of the problem hadn't hit home to me until it really hit home in a personal way. So I really see it as a growing problem and not one just for the for the rural areas like Maggie was saying, also urban areas and the issues that we're facing because of the lack of economic barriers or other barriers that come up for people in accessing justice services. So yeah, I would say this is definitely a very serious and growing problem.
The emergence of non-attorney legal advocates challenges a principle we in court administration have long upheld. Do not give legal advice. Should courts begin to advocate for this new model on a national level? Riddell Webb?
That's complex because I think that it's more than just a principle. The unauthorized practice of law is generally a rule. So I'm here in Pennsylvania, and the unauthorized practice of law applies to all people, whether you're a paralegal, any person. If you're holding yourself out as an attorney or someone who's practicing law, that's a misdemeanor of the third degree upon the first violation and the misdemeanor of the first degree on the second violation. And so we really have to be careful if we're going to have non-attorneys represent clients. With that being said, my colleagues have just spoke about legal deserts. Liz told that story about how you have one attorney handling all of these problems. And to some extent, that seems like that could pose some risks on its own, just having one attorney manage all the different types of complex issues. So I think that in a case like this, I would not recommend that all courts advocate this new model on a national level, but I think that we should look at what the needs of your state is and determine what solutions that you have available to you.
Liz?
Yeah, absolutely agree with Credell. I think that the challenge is that for court staff, and the way we're asking the question, should we advocate, doesn't clarify that, but I want to say for court staff, should we advocate for court staff to be advocates, non-attorney legal advocates? No. And in Oregon, as an ethical issue, in Oregon, we've dealt with it in certain ways. We've got a statute that says that if the clerk gives legal information or provides assistance with forms, then it is not giving legal advice, right? So the statutes have defined that a little bit better for us so that we can have court staff do those things that provide procedural justice that are not legal advocacy. And I know that I've heard lots about Alaska's programs for these things as well. They're fantastic. They have similar statutes to us, I believe. So it's just really important that as court people, we can advocate for these programs, but that they shouldn't be court-based because we must remain neutral in the program. In Oregon, we have a new program, fairly new. The first people were admitted in 2024, I believe, that is for Oregon Limited Attorney Paralegal Certification. That's a lot of words. But what it means is that the state bar has agreed to license certain paralegals for limited legal work in landlord-tenant and domestic relations matters. And they've set up a whole laundry list of rules. They have to join the professional liability fund for insurance and all of the things. So it then doesn't become the illegal practice of law because they've adopted adding these folks as attorneys to the bar for this limited component. So it's kind of like everybody's working to solve the problem by doing what they can while maintaining everybody's standards and ethics appropriately.
Alaska has a community justice worker program. Other states, such as Arizona, have both community justice workers and limited legal practitioners. Can you explain the difference between the two? Maggie?
Community justice workers are community-based advocates, and they are either on staff with Alaska Legal Services, working as a volunteer for us, or embedded with one of our community partners, like a tribal service provider in one of our rural communities. The CJW is trained and mentored and supervised by our attorneys and other staff members here. CJWs are trained to provide very targeted legal assistance in very specific areas of the law. We have 5 areas where we have concentrated our training and mentoring and support right now, and that's in the area of food stamps or SNAP, the Indian Child Welfare Act, debt defense, domestic violence, and wills, and with additional courses being added. CJWs receive ongoing support, training, and mentoring through ALSC during, as long as they're a community justice worker. We have been granted a special waiver from our bar association that will ultimately put CJWs in our court system, which is very, very exciting. As CJWs, they're either volunteers or affiliated with ALSC on our staff. And so they're serving clients of Alaska Legal Services Corporation, right? And we don't charge for our services like all legal aid organizations. So with a limited legal technician or limited legal practitioner, as you said, we don't have these here in Alaska. So my caveat is I'm certainly no expert in these. And I know these programs really vary from state to state. But some of the differences from a community justice worker to an LLP or LLT include the licensing, the process of training CJWs as sort of a low barrier training program. LLPs go through a little bit more extensive licensing program. It often includes examinations and sometimes thousands of hours of substantive law related work. LLPs and LLTs aren't necessarily affiliated with an attorney or a law firm. They could potentially be. I know there are some, at legal aid organizations, but they're not necessarily theirs. They could be hanging out their own shingle, right? And so they can charge for their services, right? If you're not affiliated with a legal aid organization. So they are really perhaps targeting a different market, right? Credell, I think, mentioned, that they're really moderately income folks who may not qualify for their local legal aid organization, but also, as we've already talked about, retaining a private attorney is just completely out of reach, given that they charge, several $1,000 retainers typically. So the LLPs and LLTs may fill that void and be able to provide a lower cost legal services.
A common argument that I hear against community justice workers is that they're stealing revenue from attorneys. The counter argument is that the litigants who use community justice workers would not go to an attorney even if the justice workers did not exist. How well do these two arguments stand up to scrutiny? Maggie?
The issues that community justice workers are assisting with are not taking work from private lawyers for a number of reasons. One, there are not lawyers in many of these communities where folks are. Two, the types of issues that our community justice workers are tackling for folks are not the type of issues that a private attorney is going to take. For example, our community justice workers handle issues with the SNAP program or food stamps. There is not a private attorney. That's a program for low-income individuals. So by definition, this person is at or below the poverty level. They are certainly not going to be able to afford an attorney. An attorney is not likely to take on a case, paid case. It just seems completely out of the realm of possibilities to take upon a paying client to help them fix their food stamp problem. These are just issues that private attorneys aren't going to see. And then even if you look at the data for court cases, right, I think around 75% of the cases in the Alaska court system, at least one person is unrepresented. And I know that's not uncommon across the board. I see Liz and Credell shaking their heads. So, even if you look at within our court system, even once our CJWs reach that point of representing folks in court, there's so many. Folks to help that, we're not taking away from work that private attorneys could be doing.
You asked a question a minute ago, I think about, lawyers arguing, and you kind of mentioned it just now too, about lawyers not being fans of these programs, these limited programs. But, I have a lot of experience in this. And in my conversations with members of the bar, I feel like what I'm hearing, and Maggie and Sarah disagree with me if you feel this way, but what I'm hearing from practicing attorneys is that the services that these folks are offering, whether it's our family court assistance or whether it's the limited legal services paralegals here in Oregon, are not services that they're trying to provide. Like they see that as an opportunity for all of the people that they turn away. Even 20 years ago, when we were starting up our family court assistance office and it was kind of new, or 25, whatever it was, these are things that the lawyers wanted to happen so that they could turn those people to a place where they could get some help, because they knew, and I almost felt like some of them were like, phew, I don't have to do so much pro bono work. I don't know, I'm not a lawyer, but I just felt like they really felt like the more the merrier, kind of in the way Sarah was talking about the scope of services provided in the medical community being similar to what some lawyers I talked to were looking for in the legal community as well.
If it's okay to add to that, I feel remiss when I, answered your question earlier that I didn't emphasize that the Alaska Bar Association was very supportive of the community justice worker movement and remains so. They are a huge champion, as is the Alaska court system and the Alaska Supreme Court. So I think, I don't know if, I think some states are softening about it. I don't know that states are necessarily still having that knee-jerk reaction. I think what Liz is saying is spot on. If we have a client in Alaska, in rural Alaska, who walks into the local attorney's office and needs a will and can't pay market rate, they're going to tell them to go see Alaska Legal Services Corporation, and we can have one of our community justice workers help with a will for free. So again, these aren't folks who are able to pay market rate services or market rate for legal services, and they're, the issues they need help with aren't things that private attorneys are, chomping at the bit to do, understandably, because they are folks, they are things that folks can't pay for. So, but I just do want to emphasize and really give credit to particularly the Alaska Bar Association for being as supportive of it and how supportive it remains with the community justice worker movement. So.
Okay.
Yeah, and I wonder, it might be interesting, Peter, just to add to that, to explore whether bar associations and courts are more open to these programs in states and areas where legal deserts are becoming more of a problem, right?
Mhm.
So, because honestly, there are areas in the western states where it's hours to the next area, the next urban area. So I just think that would be, and of course, Maggie and Sarah did a great job of describing Alaska for us. So they're not only is it hours away, it's a plane ride away.
Describe how community justice workers are trained and supervised. Sarah Carver?
Before potential community justice workers even enrolled in training, we have a conversation setting expectations. So we want to make sure that the potential CJW knows what the training is, knows how long it's going to take, they understand how to access it, they understand the program goals is not necessarily for personal information, but it's really to assist clients with the knowledge or provide a community education program. So that's kind of the first thing that we do with potential community justice workers. And assuming everybody's on the same page, then the trainees are enrolled in the ethics and professional responsibility course that I mentioned earlier, often along with a substantive training of their choice, often a public benefit SNAP training or potentially a wills training. So the first trainings that they encounter, they're all asynchronous, they're all online, they're all done at your own pace on your own time. They generally take about 8 to 10 hours. They're a mix of reading and videos, interactive exercises, quizzes and knowledge assessments, and then practical assignments. And they're all tailored to an 8th grade reading level. Once the online training is completed, the community justice worker is able and available to take a case with an attorney mentor. So this is done as often as needed for the community justice worker to become competent and comfortable with the subject matter that they're taking. Once they're comfortable, they can operate more independently. Community justice workers with this level of training generally write wills or assist in SNAP cases. They can appear in administrative hearings in front of administrative law judges, but the clients they're serving are still ALSC clients. They still have an attorney mentor, and an attorney still reviews the case before case closure to ensure quality service. The next level of certification then is when we're getting into the waiver, which we've talked about previously. Our first cohort is currently going through a domestic violence protective order waiver curriculum as we speak. This includes 4 components. The first is live weekly virtual classroom style training. That's about 10 weeks. There's reading assignments in between class sessions. They're required to do court watch, where they go into court or call in remotely to a court hearing. And while they're doing that, they're completing surveys where they're asked about evidence that's being presented. They need to be able to recognize case theories. They need to be able to establish, what is actually going on in the case and do that for all sorts of different cases. And that's all going to culminate into a 2-day mock trial at the end of the training. Once they've completed this training, we can present them as a candidate to the Alaska Board of Governors for waiver certification in the particular area for which they are trained. So for this first cohort, assuming they are, the waiver is successful, they will be able to practice in court on behalf of a domestic violence survivor in obtaining a protective order for that survivor. But the clients are still going to be ALSC clients, and we're still going to be supervising them in much the same way as in Alaska, a new attorney would be supervised.
How do community justice workers collaborate with the courts, law enforcement, and the tribal justice system? Sarah?
The CJWs collaborate in much the same way as the rest of ALSC staff and attorneys, but CJWs, by definition, come from the communities and are part of the communities they serve. So they can really help the client navigate through systems in a way that's really a lot harder for an attorney to do because of time restrictions or capacity limitations of the attorney with a really high, potentially, caseload. The CJWs can work collaboratively within the systems, while the attorneys representing clients are often a part of the client's life for that one legal intervention. The CJWs are really able to offer a more wraparound service for that particular client. So an example of how this works in Alaska, a client comes to Alaska Legal Services for help with a SNAP case. If an attorney is assisting them, the attorney is able to file an appeal, potentially negotiate on behalf of the client, appear in front of an administrative law judge. If a CJW is representing the person, they can do all of those things, but they also often have more capacity to do that plus. Because the CJW is often from the community, they're often a lot more in touch with the resources of that community. So a lot of times they can actually find food security in the interim of the case. They know about local programs that the client might be eligible for that maybe someone from outside the community might not have knowledge about. They can really go through the client's case and work with the client to make sure that they're getting any services that they're actually eligible for. Administrative law judges have also told us they really appreciate when community justice workers work on behalf of the clients for several reasons. First, if someone's appearing pro se, they're much more likely to no show for hearings, where if a community justice worker is representing the client, they are there for the hearings. They're not missing notices that are delayed by mail or bad phone systems. It guarantees that there's help for the client when they're navigating the needs of the case. Often there's additional information that needs to be gathered, like income information or resource information, and the CJW can work hand in hand with the client to make sure that information is gathered and appropriately given to the court or to the public assistance system. And the cases just simply take much less time on the docket when there's an experienced representative handling the case. In regards to tribal courts, of course, every tribal court is different. Every tribal court has its own rules regarding who can and cannot practice. I know CJWs in other states do practice quite a bit in tribal court. In Alaska, it looks a little bit different because we have many tribes and many different judicial systems. So it's often more frequent for a tribal council member or an employee of the tribe to actually take the community justice worker training and become a community justice worker themselves, and then help tribal members navigate the systems that they're trained within. And then, as Maggie mentioned earlier, we also have some tribal nonprofits who have people paid on staff who are working as part of their job to do community justice work. So for example, in the YK area, there's a tribal nonprofit that has a realty department. All of the employees of the realty department have been trained in how to do wills, and as part of their job functions, they go to remote villages, talk to people about wills, offer their services to elders who might have restricted native property, and make that a priority for them to write wills for those clients.
There now seem to be competing models to the use of community justice workers. More extensive teleconferencing is one option for offering services in a legal desert. Another on the horizon is the more extensive use of artificial intelligence. Are these models more or less attractive than the use of community justice workers and limited legal professionals? Maggie?
Pete, I don't really see these things as competing innovations. I don't think they compete with the community justice worker model. These are all bigger pieces of a picture or a puzzle that are aimed to increase access to justice for people in this country. As we have, I think, all agreed at this point, you know, there are serious access to justice issues. A lot of people are going uncertain. People aren't recognizing their issues as legal. They aren't able to, you know, file court cases. They're not getting in front of the court. They're simply, and they're not getting representation, right? There are problems across the board. So we need a multi-pronged approach to fix that, right? So I don't think these are competing innovations. You know, AI is a really incredible opportunity to help legal aid organizations like ALSC scale its services more effectively. And we're already testing to see how AI can enhance our CJW program, which is really exciting. And I think we can all imagine a future where AI makes legal services more affordable across the board for everybody in this country. As to teleconferencing, you know, Alaska has used teleconferencing way before it was cool even. Because as I have already described, you cannot get to courts very easily here. So we've been using it for a long time, and we know it alone will not close the justice gap. That flexibility is really great. It facilitates folks attending court hearings, but it alone won't solve this problem of legal deserts or access to justice. But when you put all these things together, community justice workers, LLTs, you know, flexibility in court rules, AI, you know, all the other technology, I think we can really make some serious progress in improving access to the justice system for everybody.
Credell?
I have to agree with my colleague Maggie here in terms of I don't see them as competing, but maybe they complement each other. So if someone is able to have access to teleconferencing, AI, and they have these LLPs, they'll probably try to use all of them. But when you say more or less attractive, now that's going to depend on who you mention. So for example, if you're in a state that has very strict rules on unauthorized practice of law, that state may be more comfortable with something like artificial intelligence because it's on that person. That person used it, and that's on them. There is not like a second person there who is representing them or assisting them. It's that person that using it on their own. So there is a little bit of a difference there. But then even we know that our artificial intelligence gets things wrong. So what happens then? Maybe it just falls on the person. So it really depends on who you talk to. But I can tell you, now, artificial intelligence, even when it comes to people who are hiring attorneys, people are looking up what their attorney is saying and putting it into AI. And it's not just in the legal profession. Sarah earlier was drawing a comparison between like medical professionals saying everyone's not doing the brain surgery, right? There's all different levels of medical professional, but you'll have clients that come in doctor's offices now and they're looking up what their doctor is saying on artificial intelligence. So this is just groundbreaking work that I don't think is going to impact just individuals who are unable to obtain an attorney, even the individuals who are getting the attorney. They're using the artificial intelligence system to see if what they're getting what they're paying for, essentially. And so I think this is going to be something that doesn't go away. I think to some extent, if AI gets really good on some of these routine issues, maybe you then have sort of an HI plus HI, as Sherm says, the Society for Human Resources Management. So you have that human intelligence plus the artificial intelligence, and you come with some sort of a robust process. In fact, maybe AI will enhance some of these legal advocates. Maybe there'll be more software available, and then maybe it will also enhance chances for self-represented litigants to have somewhat of a resource if they don't have an attorney, or maybe they don't even have access to a legal advocate. I mean, when you're talking about states that you have to drive miles and miles and there's only one attorney, is there even a legal advocate there? I don't know. So I think that artificial intelligence can be anywhere. So I don't see it as competing, and as Maggie said, I do see it as something that will complement.
A heartfelt thank you to Maggie, Sarah, Liz, and Credell for sharing their thoughtful perspectives on the emerging issues of legal deserts and non-attorney legal advocates. How might this phenomenon evolve? And could it become a nationwide model for expanding access to justice? We'll watch closely how this concept develops into the future. And to you, court professionals joining us today, your commitment to customer service and access to justice forms the very foundation of our court system. Thank you for all that you do. I'm Pete Kiefer, and thank you all for participating today. We'll see you all on the next episode of A Question of Ethics Conversation. Thanks for joining us today. The Question of Ethics Conversation is a regular segment on ethics, courts, and court administration. Today's episode will be available on our website, in the Court Manager Journal, on the Court Leader website, on YouTube, Facebook, iTunes, LinkedIn, and on X, formerly known as Twitter. Become part of the conversation. Join us live when we hold the Question of Ethics Conversation. Episodes are held immediately following the monthly NACM Ethics Subcommittee meeting on the fourth Thursday of the month. Check the NACM Committee webpage for the schedule and Zoom link. If you have questions, comments, or ideas for future conversations, email us. Our address is ethics@nacmnet.org. Did you hear an interesting comment by one of the panelists that you would like to listen to again, but you don't want to search the entire episode to find it? The Additional Resources section on the webpage has a question time marker sheet. Find the discussion question on the sheet, and next to it is the time that question was asked. You can quickly fast forward to that time and listen to the panelists' comments. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leader website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the hosts and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.